and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Faumina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael Berg for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner, also from the ATF.
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant L. Scholes, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the two pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
Did you mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio-video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there to Utah County Jail. Were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famawina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Falmina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement.
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at, it was the St. George, well, it was at the St. George court office, courthouse there. They met and discussed briefly, just kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. It sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained.
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building, on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile and as a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up and fired. It still had the bullet projectile in the end. It's still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider. It was Lauren Hunt Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
That's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview.
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep, yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not, I did mention that defense.
This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem, because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 1102 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state. There are also.
I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16?
Significant. We could do it line by line or page by page. I know we have had hearings in this matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that, but I'm going to give the court categories.
Thank you.
Without referring to specific portions. There are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So I apologize. I don't mean to interrupt you.
Oh, no,
I
it's
just
fine.
want to categorize it and put it in a box. So what is the what objection under the rules of evidence is that specifically? What are you boxing that as?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says. There's a best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here.
Sure.
Because there are two exhibits that I'm very confident are coming. There are portions which are not relevant. There are portions which I believe are inadmissible when the court balances under 403 the probative value versus the prejudicial value, especially in light of the manner in which this hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay. We have relevance issues, and we have 403 issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today, in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Okay. Thank you.
And I do.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview, that it's at issue here, is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears to likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Archuleta has been invoked. We respect and understand Archuleta. Respectfully, Archuleta.
All right. I want to address the objections before me, and starting with Mr. Novak made a hearsay objection as it relates to Mr. McBride, and the court agrees. It is hearsay. At the same time, I'm only going to consider Mr. McBride's statements to provide context for the things that Lance Twiggs says and for their effects on Lance Twiggs. And as such, the hearsay objection as it relates to the statements of Mr. McBride in State's Exhibit 16 is overruled. Turning to relevance, rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript as it relates to State Exhibit 16 may contain irrelevant information, but I will reserve whether I consider those portions until I've heard the rest of the state's evidence. Therefore, as it relates to relevance, that ruling is reserved. Now, turning to the other objection, which is Rule 403, prejudice. As I am acting as a magistrate, I do not have the same concerns that my decision will be influenced by undue prejudice as that of a jury. Therefore, for purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. And when I say audio, I mean audio and video, so both. I recognize there's approximately only 1 minute after 3548. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning until that page 19, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going to allow to be published. And I wish to differentiate. I'm considering it all. But for publication purposes, that portion is not going to be permitted to be played in the courtroom.
Your Honor, would you state those times again that you
think a closed hearing is appropriate? Setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay? Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay? I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially on in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding. And there are reporters
Of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. The second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if this information is in the public already, I shouldn't be in the business of trying to now keep that from the public for two reasons. One, it's already out there. Second, it suggests to the public that something else lurks in there, something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this that are already public. And so I again, recognizing how much time the court has already invested in this, I believe it's wise, and I believe it would help avoid potentially making a mistake that the court later on then thought, oh, I wish someone had brought that to my attention, to check whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I have, Your Honor.
Thank you. And, all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk's family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. And we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties? Mr. Novak, and your mic's muted.
Yes, we just want to say that we totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media counsel's suggestion that because the state, in our view, improperly disclosed what the state is going to call a confession in charging documents does not mean that this court can just let it go. This has been the most transparent criminal proceeding I've ever been involved in, and I am sure it will continue to be transparent. But there are some things which the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to the Kirk family, and with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have, thank you. All right, I appreciate that guidance, Mr. Novak. So taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to 20 minutes and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 32:55 until 35:48. Does that comport with what I previously said?
Yes.
All right. And then from 35:48 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes, under my analysis, under 403, going to the last part, needlessly presenting cumulative evidence. And based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act. But I'm trying to act in the interest of justice in making this balancing act, and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state,